Info Bites, let's get right into it. Real-life facts involving bizarre legal arguments, technicalities, and strange court cases. The case of the dead prisoner, the source case. As mentioned, Benjamin Schreiber argued his life sentence ended when his heart stopped and he was revived. The court ruled he must remain in prison for the rest of his natural life. The self-suer for civil rights violation. A prisoner named Robert Lee Brock sued himself for $5 million in 1995, arguing that by committing a crime and drinking, he violated his own civil and religious rights. He requested the state of Virginia pay the damages on his behalf since he was indigent. The case was dismissed. The $67 million pants lawsuit. In 2007, an administrative law judge in Washington, D.C., Roy Pearson, sued a dry cleaner for $67 million after they allegedly lost a pair of his pants. He cited various consumer protection laws and claimed emotional distress. The case was dismissed and he was later disbarred. The No Cheese Quarter Pounder lawsuit. A man sued McDonald's, that's because they charged the same price for a Quarter Pounder sandwich, whether he ordered it with or without cheese. He claimed it was unjust enrichment. The lottery ticket technicality. In the late 1990s, in Ontario, Canada, a man named Joel Eifrigan won a lottery prize but argued the corporation was in breach of contract because his ticket was timestamped 1 second after the sales cutoff, even though the machine printed it late. The Supreme Court of Canada eventually ruled against him. The Actus Reus Mens Rea murder loophole. In the 1950 case of R.V. Fabo-Melli, 4 men assaulted a victim, thinking they killed him, and threw his body off a cliff to make it look like an accident. The victim was actually still alive and died from exposure on the cliff. The defendants argued they lacked the necessary criminal intent, mens rea, at the time of the actual death, actus reus. The court rejected the argument, ruling it was one continuing transaction. The right to trespass yourself, one bizarre but largely mythical or theoretical. Legal arguments suggest that since a jail cell is a prisoner's dwelling, the inmate could theoretically claim the jail is trespassing by locking them in. The haunted house rescission. In the 1991 New York case of Stambovsky v. Ackley, a buyer sued to get out of a contract after discovering the house he agreed to purchase was widely reputed to be haunted. The court granted the rescission, effectively ruling the house was haunted as a matter of law, because the seller had previously promoted the haunting. The beer belly defense, autobrewery syndrome. In a few DWI/DUI cases globally, defendants have successfully argued they were not criminally responsible for their high blood alcohol content because they suffer from autobrewery syndrome, a rare medical condition where their digestive system produces alcohol after consuming carbohydrates. The Red Bull doesn't give you wings? Class action. A man sued Red Bull in a class action lawsuit for false advertising, claiming the drink didn't literally give him wings or significantly enhance his athletic performance, as implied by the long-running slogan. Red Bull settled the case for a significant amount, though without admitting wrongdoing. Is a tomato a fruit or a vegetable? The tariff case. The 1893 U.S. Supreme Court case, Nix v. Hedden ruled that for the purpose of the Tariff Act of 1883, a tomato is a vegetable. Botanically a fruit. The court ruled based on the common language and the manner in which it is used, served with dinner, not dessert. Are Pringles potato chips? The tax case. In a 2008 UK VAT value-added tax case, Procter & Gamble successfully argued that Pringles were not potato chips, crisps, because they contained less than 50% potato and were made from dough, meaning they did not qualify for the tax placed on potato crisps. Is a Subway sandwich a foot long? A man in Australia sued Subway because their foot-long sub measured only 11 inches. A class action lawsuit later alleged the same issue in the U.S. Subway, settled and agreed to make sure their bread was always 12 inches long. Is a swan a fish? In medieval English law, sometimes used to resolve disputes over fishing rights, Swans were sometimes technically categorized as fishes because they lived in water and were eaten during Lent. The fallen body. Lawsuit. In Illinois, a woman waiting on a train platform was struck and injured by the body of a man who had been hit by a different, high-speed train. She sued the estate of the dead man. The court dismissed the case, ruling the dead man could not have reasonably foreseen where his body parts would land after the collision. The weatherman lawsuit. An Israeli woman successfully sued a television weatherman and his network after his inaccurate forecast led her to leave the house without an umbrella, resulting in her getting caught in the rain, becoming ill, and missing 4 days of work. She was awarded compensation. Suing God and Satan. Various lawsuits have been filed over the years against God or Satan, often by pro se self-representing litigants, usually claiming negligence or intentional infliction of emotional distress. All such cases are typically dismissed due to lack of personal jurisdiction or being deemed frivolous. The necessity cannibalism case. In the 1884 case of R.V. Dudley and Stevens, 4 shipwrecked men ran out of food. 2 of them killed and ate the youngest, Richard Parker, to survive. They were rescued and later convicted of murder. They argued their actions were a necessity to save their own lives, but the court ruled that necessity is not a defense to murder. The neighbor's fox farm. In the 1936 English case Hollywood Silver Fox Farm, Limited v. Emmett, a neighbor deliberately fired guns on his own land during the breeding season of the fox farm next door to deliberately frighten the foxes into miscarrying, thereby causing damage to the business. The court granted an injunction, ruling that a person can be restrained from doing on their own land something that is deliberately designed to injure a neighbor's business. The talking cat. A pro se litigant in Washington state claimed his case was prejudiced because the judge in his hearing was biased against him, allegedly based on an ex parte conversation with the litigant's cat. The Court of Appeals still ruled against the litigant but acknowledged the strangeness of the claim in its opinion. No smoking near the police car, South Africa. A man successfully overturned his fine for smoking in a non-smoking zone, a shopping mall. Entrance. After his lawyer argued that the government failed to gazette the required sign specifications, thus making the sign advisory, not legally binding. The missing legislative signature. A bill passed by the U.S. Congress was technically declared null and void after it was discovered that neither the Speaker of the House nor the President pro tempore of the Senate had actually signed the final enrolled version of the bill before it was presented to the President. The unreasonable liability waiver. Courts have occasionally ruled that liability waivers for dangerous activities, like bungee jumping or skydiving, are void or unenforceable if the injury was caused by gross negligence or if the waiver's language was deemed too ambiguous, one-sided, or unreasonable. The unforeseen copyright loophole, monkey selfie. In the famous monkey selfie case, a macaque named Naruto took a self-portrait with a photographer's camera. PETA sued on the monkey's behalf for copyright ownership. The U.S. Copyright Office ruled that animals cannot own copyrights, leading to a bizarre legal debate over who, if anyone, owned the image. The freedom of the press to print counterfeit money. In the 19th century U.S., a technicality arose over whether the First Amendment's freedom of the press could be argued to cover the printing of counterfeit money, as it was technically an act of printing. The Supreme Court decisively ruled that it did not. Happy Birthday copyright loophole. Until 2016, the song Happy Birthday to You was technically under copyright, forcing creators in movies and TV to pay royalties. A class action lawsuit proved that the copyright was only valid for a specific arrangement of the song, not the melody, and lyrics itself, effectively putting the song back into the public domain. Just walking around naked, Kansas, North Carolina. Laws in some U.S. states like Kansas can be interpreted as allowing a person to walk naked in public provided they are not engaging in overtly sexual or lewd behavior that would be considered an indecent exposure violation. The focus is on behavior, not just the lack of clothing. The case of the missing, a famous case involving a $10 million oil drilling contract was decided on the placement of the word, the, and whether it was used to combine two different clauses or to imply a separate condition. The 365-day sentence technicality. A prison sentence of exactly 365 days in some jurisdictions might technically fall into the category of a misdemeanor instead of a felony, which often requires a sentence of 1 year and 1 day or more. A defendant may argue for the 365-day sentence to avoid a felony record. Gödel's loophole. The famed mathematician Kurt Gödel reportedly discovered a serious logical flaw, inner contradiction, in the U.S. Constitution that he believed could allow the U.S. to legally become a dictatorship. He was about to tell the naturalization judge during his citizenship test in 1947 before friends Albert Einstein and Oscar Morgenstern intervened. The exact loophole remains unknown but is theorized to relate to the amendment process.
We'll be making more similar videos. Please subscribe.